I expect the bill will receive wide support from all parties, and I commend the bill to the House.
The question is that the motion be agreed to. Call Charles Cheval.
Thank you, Mr Speaker. Mr Speaker, the Minister consulted the opposition about the bill, and we indicated on the basis of his undertaking that it would contain only technical amendments in the nature of a statutes amendment type provision, that we would support the legislation, and we will do so. And sir, may I just take this opportunity to talk a little bit about the history of the legislation to which this amendment relates, because that is an approach to criminal justice that we've attempted to show in good faith in this Parliament and in the last Parliament. The Minister referred to the history of the substantive legislation, and he made reference to the amendments that had been made in the Select Committee. He'll remember those well because he chaired that Select Committee, but also in the Committee of the Whole. And it's at the Committee of the Whole that I think the House needs to just remind itself of what was done with this legislation, because I think we have some lessons that if government members want to learn them, they can. And we could avoid this sort of thing happening again and again, where we have to come back and repair legislation that was only passed within the last 12 months. And the history that I refer to, sir, is this. The original legislation was a big reform to criminal procedure. I'm a little unsure of the grandiose claim that it's the largest reform to criminal procedure in 50 years, but I don't blame the Minister for making that call. I see he was reading his notes, and I've heard his predecessors make it. It certainly was, though, a major reform, and members of the opposition agreed in principle that we could do better in terms of the processes of our criminal courts. Where we were concerned was with the very sweeping nature of the original substantive reform proposals. And in particular, we were worried about the restrictions on the right to trial by jury, and also to alterations to the presumption of innocence, where essentially the original legislation would have required the defence to cooperate with the prosecution in a way that would offend that principle. And I think it's instructive to remember that the Law Society was on board with those concerns, much of the legal profession, many of the civil rights groups, and eventually the opposition to the measure, because of those particular proposals, grew so great that the Minister at the time, Simon Power, lost his majority as to the measure progressing. And that was because the ACT Party in particular, which was better represented in the previous Parliament, at least as far as numbers are concerned, withdrew its support for the legislation. It was concerned about the jury trial and presumption of innocence erosions in particular. And I want to pay tribute to Rodney Hyde for the way in which he dealt with the matter, because once he realised the extent of the concerns and of the erosion to those fundamental liberties that the original bill would represent, he did withdraw that support, and that did force the Minister to the negotiating table. Now, as a result of that negotiation, the changes that were mentioned by the Minister were made in the Committee of the Whole. They followed on from some changes in the Select Committee process as well. But if we'd had a process from the beginning where the government had been willing to sit down and say, look, this is the aim here, we want to reform criminal procedure, the current manner of procedure is clumsy and we think we can do better, well, we would have cooperated. We would have talked about the principles, we could have avoided the excesses of the original bill, the Minister wouldn't have lost his majority midway through, and we probably wouldn't be in the position that we're in now. And I'm not saying this, sir, because I like to get up and say, I told you so. I'm saying it because I think if we do want to achieve some certainty in justice policy generally, and in criminal justice policy in particular, then we ought to try to treat this legislation as a bit of a learning exercise. It wasn't as if this wasn't foreseeable, and I want, Sir, just to read out to the House what the Law Society said to the Justice and Electoral Committee when the Minister was its chair at the time that it was considering the substantive legislation. He said, firstly, cross-party agreement is needed on criminal justice instead of the continued politicisation of a matter that requires coherent cross-party agreement. And he went on to say that to predict that the bill as introduced would only last around a year before Parliament would be required to review it again. So it was critical in his view that we give careful consideration to a very important piece of legislation and actually provide certainty going forward. Now, Sir, that's pretty instructive when you think about the time that amending legislation of this nature requires to be devoted to it. This is not a matter where there's particularly significant political disagreement. Speeding up the criminal process while maintaining basic human rights is not something that I don't think is taken issue with across the House. But because the Minister was just determined to pursue his agenda and did so until the very last moment when he lost political support, we are now in the position where the hasty amendments that had to be made as a result are now having to be repaired. So if we are trying to learn some lessons from this, then we should also think about another thing that the President of the Law Society said at the time that he made his submission, and that is that we've got this process around the wrong way. We're dealing with procedure which is about in the middle of any sort of ideal reform process, not at the start. There are two substantive acts of Parliament, the Crimes Act 1951 and the Summary Offences Act 1957, that are ancient. They have been amended many times. They need reenactment, not only because they're a minefield to try to read and construe, but because they're out of date with contemporary social conditions. Anyone would think that if a criminal law reform project were being pursued in good faith, if it were to live up to the name of the greatest reform for 50 years, well, a government might actually start with the substantive legislation rather than leaving acts that are over 60 or 70 years in vintage on the books without reform. They might even think about looking at the drivers of crime on a non-partisan basis. And that was an invitation that my colleague and friend Leanne Dalzell made to the previous Minister, particularly in respect of alcohol law reform, to no avail. She received no positive response to that. And if we want to consider the whirlwind that is being reaped as a result of that, we need only look as far as the botched alcohol law reform exercise which this Parliament is scheduled to complete in the next 4 sitting days. But, Sir, as I said, the Law Society said this: start with the drivers of crime, deal with the substantive statute, then you might be able to get coherently and rationally to criminal procedure issues. You might even then look at the evidence rules and the rules of court that are applied. But for some reason, we had this start of the process right in the middle on the procedural points. We had, as I described earlier, the political fiasco that resulted when the Minister wasn't able to push the erosion of fundamental rights through that he wanted to achieve, and the resulting amendments that were not made in a coherent fashion, which bring us back to the position that we're in tonight, where we're having to do a rushed fix-up job in the Parliament now. And, Sir, this approach is not limited in the justice field to criminal procedure. I mentioned alcohol law reform. I could talk about legal services and legal aid, where the opposition has always accepted that efficiencies and rationalisation should be made, but not on the basis of fiat, not on the basis of the Minister telling the profession and consumers of legal services that she knows best, but actually sitting down and negotiating changes. We had the family court reform legislation read a first time today, and that's another classic example of a position where the family law practitioners came up with efficiencies and a plan to reduce costs in the family court. They were simply ignored by the Minister, who thought and thinks that she knows better because she has the advice from the officials that she seems determined to bulldoze through. Sir, this is not a coherent way to run justice policy. And if the government continues this way, we'll simply be back here again dealing with these fix-up jobs ad infinitum.
Call Tim McIndoe.
Mr Speaker, I thank the member who's just resumed his seat for that historical discourse and in particular for his confirmation that the Labor Party will